Be host permission. Good evening. Good evening, friends. Okay, let's begin with our discussion. So yesterday we were in the process of discussing the different powers and jurisdictions of Supreme Court, correct? So we had started with one of the jurisdiction of Supreme Court, which is the federal jurisdiction of Supreme Court. If there is any dispute between federal units, the only place where you can take up such disputes is the Supreme Court. So we dealt with that. And the next kind of jurisdiction is what is called as the writ jurisdiction of Supreme Court. So this is the power of Supreme Court to issue writs. Okay. So what do we mean by writs? I'm sure you would have been exposed to what the writs are when you had your discussion on fundamental rights, correct? So you know why writs should be issued. Why do you think writs need to be issued? This is the power of Supreme Court to issue directions. Actions in the sense court directions. Writ means a court direction. Right, writs are orders. So whenever fundamental rights are violated, Supreme Court uses writ as a tool. That's very correct. So writs are issued against the executive orders. A policeman coming and arresting me unnecessarily. Okay, a policeman coming and arresting me without the backing of a law. For no reason, he's coming and barging into the room and he's coming and arresting me. He is depriving me of my liberty. He is arresting me, detaining me in a police prison, in a police lockup. So basically, he is depriving me of my freedom, liberty. So my fundamental rights get affected. So Supreme Court, being the guardian of citizens' fundamental rights, because of its powers, Supreme Court, you have the power to move the Supreme Court for the purpose of issuing directions to the executive. Don't deprive the common man of his liberty. Release him. You cannot arbitrarily, you cannot take away the fundamental right of freedom available to the citizen. So release him. It is to make the court issue such directions to the executive. We have what are called as writs. Okay. And I'm sure you know about the different types of writs: habeas corpus, mandamus, prohibition, certiorari. So you'll be knowing about all the different writs. My question is, can I say Supreme Court has an original jurisdiction when it comes to issuing writs? Can I say Supreme Court has an original jurisdiction in terms of issuing writs? Is it a correct statement or is it a wrong statement? No. Yes is the correct answer. Why? Just now I'm telling you, Supreme Court can issue writs. What did you read in Article 32? Whenever fundamental rights are violated, you can directly go and move the Supreme Court itself. You can knock at the door of Supreme Court, asking the courts to reinstate your liberty once again, right? So, Supreme Court has an original jurisdiction when it comes to issuing writs. But can I say Supreme Court has an exclusive jurisdiction? Is the Supreme Court alone competent to issue writs in case of violation of fundamental rights? No, I'm sure you know about it. Even high courts, the relevant concerned high courts, can also issue writs. So that is why the writ jurisdiction of Supreme Court is only original and not exclusive, because even high courts can do this. Whereas when it comes to sorting out federal dispute between center and state, states versus center, all such kind of disputes are completely original as well as exclusive only in the hands of Supreme Court. So that this is the difference. Writ jurisdiction of Supreme Court is original, but it's not exclusive, right? So there's nothing much to be discussed about writs, and you know about why would writs be issued. So I think I can just skip this discussion and we can just move on. I'll discuss about the other jurisdictions. The next jurisdiction is what is called as the appellate jurisdiction. What is this appellate jurisdiction? Supreme Court as the highest court of appeal. That is what we mean by appellate jurisdiction of the Supreme Court. So let's say, I told you yesterday there are two broad categories of offenses: criminal offenses and civil offense. So who deals with the adjudication of criminal offense and civil offense at the district level? You have the district court, you have the sessions court, right? So if you're not happy, let's say a person has been given a punishment of 7 years of imprisonment. There is a FIR that is filed against someone on grounds of committing a rape. Okay, for rape, maximum punishment as per IPC is 7 years. Up to 7 years he can be imprisonment, he can be punished. So Sessions Court awards a punishment of 7 years of imprisonment. So what does the person do? The person who has been given the punishment, he is not okay with the punishment. So he would go and challenge the judgment in the next higher court, which is the High Court. And if the High Court also once again says, yes, the Sessions Court judgment is right, you deserve to be punished. So 7 years of imprisonment. Again, the person is not happy with the judgment of High Court. He can go and challenge it in Supreme Court. So I can say, criminal matters, Supreme Court does not have original jurisdiction, but Supreme Court has an appellate jurisdiction over criminal matters, right? As you know, it is the highest court of appeal. You cannot go beyond the Supreme Court. There is no other court beyond Supreme Court. Okay. So this is the appellate jurisdiction of Supreme Court with respect to criminal offenses. Same is the case with civil offenses, civil disputes. District Court not happy, High Court not happy, go and challenge it in Supreme Court. Okay. You have to know that both civil as well as criminal courts, they start from the district level. But with respect to civil cases alone, certain civil cases, they can even be challenged directly. So certain civil cases, it can be directly even taken up in some high courts, not all high courts. So for certain civil cases, for example, Madras High Court is one such high court. You don't actually have to first start in district court. Okay, you can directly go and challenge, and you can go and fight a dispute, civil dispute, in a high court also. Certain high courts alone have these kind of powers, the old high courts. Okay, so they have been doing it. So hence, even after independence, they are still doing it. New high courts, they don't have these powers. So those old high courts, Bombay, Calcutta, Allahabad High Court, and Delhi High Court also has this power. So wherever, in some high courts alone, you have this provision where civil disputes can even start directly in some high courts. And if you're not happy, you can go and appeal it in Supreme Court. Okay. So this is with respect to appellate jurisdiction. But let me tell you, in criminal cases, there is something that you will have to notice. Just because I have been given a punishment by High Court, it doesn't automatically mean that I will go on an appeal to Supreme Court. No. It is the discretion of the Supreme Court to entertain a case or not to entertain a case. Okay. For example, I'll just repeat it. Let's say it's a case of rape. Okay. And Sessions Court has given a punishment of 7 years of imprisonment. So I am not happy. So this is all with respect to criminal cases. So I am aggrieved. I go and challenge the decision of the Sessions Court in a High Court. And what does the High Court do? High Court okay, and now I go and appeal it to Supreme Court. It cannot be done automatically like that. Supreme Court will not entertain it. High courts are there. High courts are good enough to dispose criminal cases. All criminal cases need not go up to the level of Supreme Court. So if somebody wants to go to Supreme Court, the order of the High Court must be certified by the judges. The judges must give a certificate that it's a very complicated case. So I have done my best, but I think that Supreme Court judges can even do better justice to this case. Even though I have given my judgment, I think this is a case which is fit enough to go on appeal. So high courts in criminal cases must give what is called as certificate of fitness. Okay, it is only on the receipt of certificate of, it is only if the High Court judges who have given the judgment, if they feel that the case is a really sensitive case, the case really can have a further oversight. Okay, one more round of application of mine can go into such cases. If the High Court judges feel so, they can give a certificate of fitness that it is a fit case for appeal. Then you can go to the Supreme Court and file a challenge against the order of High Court. Otherwise, Supreme Court will not entertain under the appellate jurisdiction. Because see, as a lawyer, if I have to file a case challenging the order of a High Court, in a Supreme Court, if I have to file a case, I'll have to go and file an appeal petition. There are different forms of petitions. If my fundamental right is violated, I'll have to go and file what is called as the writ petition. Supreme Court has a number of petitions. Writ petition is to be filed if there is a case of violation of fundamental rights. Similarly, if I'll have to appeal against the order of a lower court, I'll have to go and file what is called as an appellate petition. Appeal petition has to be filed. So when a lawyer files an appeal petition, the court will look into the judgment. It will first satisfy that there is a fitness certificate. It is only if there is a certificate of fitness, then Supreme Court will decide whether to take up this case. Okay, the judges, see, it's not each and every person's right to go and get your case heard in Supreme Court. It is a discretion of the Supreme Court. Okay, you cannot say that I am a citizen of India, so Supreme Court must hear my case. I have come on an appeal. You are bound to hear my case. No. It is the discretion of the judges. The judges will look into the judgment of the judges who have passed this order in High Court. So they will look into the judgment. If they find that yes, this is quite a complicated case, so let me hear it. If the Supreme Court judges who are going to, before whom the appeal petition is filed, if they are satisfied that it is a fit enough case, only then they will accept this appeal petition and the case will be heard. Okay, it is a judge's right either to hear the case or not to hear the case. Okay, it's not a citizen's right to have all his cases heard up to the Supreme Court levels. It's not at all the case. Okay, but in some cases the Supreme Court is bound to hear. Some cases the Supreme Court, if a person files an appeal petition, Supreme Court is bound to give the person a hearing. What do you think could be that kind? What could be the nature of the cases? Can you think of something? Why would it be bound on the part of Supreme Court to hear certain kinds of cases? Can you think of any such grounds? Criminal matters, criminal cases. No, violation of fundamental right is a writ jurisdiction. Okay, so even there, it is the Supreme Court which has the discretion. Supreme Court will determine whether really his fundamental rights are violated or not. Writ petition will be filed by the lawyer. Supreme Court will go through it. Oh, this is not a violation of fundamental rights. Police has followed the correct procedures, so you don't waste the time of the court. Your writ petition is dismissed. Supreme Court has the discretion. Only in certain cases, Supreme Court does not have the discretion. Supreme Court has to give a hearing. What do you think would be the nature of such cases? Corruption cases? No. Okay, rarest of the rare cases, right? But public outrage is not a reason, it's not a ground to make Supreme Court bound to hear a case. I'll tell you, yes, Harini's answer is partly right. If one appeals after High Court gave him a wrong justice, that's correct. See, Why? But how do you define wrong justice? In my opinion, because I am the person who has been given the punishment, in my opinion, that judgment is a wrong judgment only. Okay, that is why I am going to Supreme Court. So appeal is a challenge. Appeal is actually a challenge against the wisdom of the judgment of the lower court. So I feel that the judges could have used their mind in a better way, in a different way. They have missed out certain important evidences. I am not satisfied with the judgment. It is not an intentional foul play on the part of Supreme Court, on the part of High Court judges. I am not suspecting the intention of the High Court judges. But what I am not convinced is the wisdom of the judgment. So I am going to Supreme Court on an appeal. So appeal is not appeal has nothing to do against the intention of the judges. Okay, you're not questioning that. You're questioning maybe there could have been a better judgment. That's all. Yes. Capital punishment, death sentence. If a High Court grants a death sentence, okay, and a person is executed, so it's a matter of life and death. Once he is executed, he cannot come back alive. It is only when it comes to death sentences, and that too in certain cases, Supreme Court, there is a right for the convict to go and challenge the order of High Court. Only in certain death cases. What kind of death sentences? Let's say a Sessions Court, there is a case of murder which is being heard. Okay, so let's say Ram is the murderer versus state of Tamil Nadu. Okay, Ram has murdered someone in Tamil Nadu, so Ram is being prosecuted. Sessions Court is where the hearing first happens. Okay, so Sessions Court, the case is going on. Meanwhile, Madras High Court, it has a power of superintendence over the lower courts. Supreme Court has the power of superintendence over all the other high courts. Similarly, high courts will have power of superintendence over all the district and Sessions Court under its jurisdiction. What do I mean by power of superintendence? It means that the high courts can, at any point of time, it can just take away the pending cases from lower courts. It will decide on its own and it will dispose away. This is what is called as the power of superintendence. Okay. So, if a case is being heard in a Sessions Court and Madras High Court decides, okay, let me take this case, let me hear it myself. So, this case is taken to Madras High Court. The High Court judges, even before the case is disposed in Sessions Court, the Madras High Court, maybe a 2-judge bench or 3-judge bench, they hear the case and they give death sentence. Okay, they award death. There is a chance of foul play here. What is the eagerness that needs to be shown by Madras High Court? Why not wait for the Sessions Court to give its punishment? Why does the Madras Court have to hurry? Madras High Court have to hurry to take up the case and dispose it. Why are you so eager about it? Maybe there could be some foul play, right? Maybe there could be some influence of these judges to give such a kind of a verdict. That is why a case that is being heard in a Sessions Court, if it is taken up by the High Court, and if High Court awards a punishment of death, in this case, the convict has right of appeal in Supreme Court. Even without High Court judges giving any certificate of fitness or anything, the convict can just go to Supreme Court and ask the judges, this has been done, so hear my case. And the Supreme Court will definitely hear the case. Supreme Court judges cannot say, it is my discretion, no, I will not hear it, nothing. They are bound to hear this case. Okay. And another instance, say for example, Sessions Court has given an order of acquittal. Acquittal means to allow him to go free. He is not a guilty person. He is innocent. Okay, Sessions Court has just allowed him to go free. And the state is not happy now. State is not happy. The state goes on an appeal to High Court, and High Court is giving death. Yes, he is guilty, not ordinarily guilty. He is guilty of committing the rarest of the rare crime, and hence he is given death. Look at the diametrically opposite views taken by two different courts. Even in this scenario, the person will have a right of appeal in the Supreme Court. It is only in these two scenarios a convict, a death row convict has an automatic right of appeal in Supreme Court. Okay, in other cases it is not his right, It is the discretion of the court. The court will decide whether to hear a case or not to hear a case. Okay. In these matters alone, it is the right to have a case heard in Supreme Court. But in all other instances, if you want to go on appeal from High Court to Supreme Court, there has to be a certificate of fitness. Okay, it's only on the basis of a certificate given by the High Court judges that yes, it's a very complicated question. So please dispose of this case. Okay, and okay, so this is something that you'll have to know with respect to appellate jurisdiction of Supreme Court. Basically, I don't think any of these things will be asked in your exams. What will be asked is, well, Supreme Court is the highest court of appeal. And you should not get confused. No. Even after Supreme Court, a person can go to the president. So Supreme Court is not the correct court of appeal. You cannot think on such lines. Can you understand why Supreme Court is the highest court of appeal? What actually happens before the president is not a court process. It is not a judicial process. It is an executive act of showing mercy. It's not a court where one asks the president to examine the evidences from the beginning. No, none of that court process actually happens before the president. So you have to just understand Supreme Court is the highest court of appeal. Okay. Supreme Court judges, High Court has given death. You go on an appeal to Supreme Court. Supreme Court has yes, right. Pardoning power is executive power of the president. It is not a judicial function or a judicial power. Supreme Court has upheld the verdict of High Court. It says that yes, you deserve to die. Okay. Let's say it is a 3-judge bench. They have delivered this verdict. Is everything lost for the accused, or does he have any more solutions, any more remedies available with the accused, or is it all lost? Yes, there is just one more avenue, which is called as review petition can be filed. Let me ask you a question. Since some of you have answered it right, let me ask you a question. Is the power of review, is the review power of Supreme Court? See, what is the meaning of review? The court can once again take up its own decision and it can apply its mind again. Maybe that day the decision was not correct. So once again, the judgment will be reviewed. Okay. So is it a constitutional power? Is it a constitutional power? What I'm saying is federal jurisdiction. All these are constitutionally granted to the hands of Supreme Court. My question is the review power of Supreme Court, is it a constitutional power? Is it given in the Constitution? The power of review of its own decision is a constitutional provision. The answer is yes. So that is why curative petition is a judicial invention. Review petition is not a judicial invention. It is a constitutional provision given. So be very clear about it. Okay. So let me first show you some constitutional provisions with respect to Supreme Court. What does the Constitution say? We are discussing all these things, but let's also know about, because I am perfectly convinced that UPSC will only ask you about constitutional provisions. UPSC will not go beyond Constitution, because there's so much to be asked from Constitution only in the first place. If it goes beyond the Constitution, it will go into the principles behind the making of Constitution. That can be one area where UPSC can test the candidates. Otherwise, you have to be just clear about every constitutional provision. Okay, so let's just have a look at what the Constitution says. I'll just run you through different provisions of the Constitution, okay, so that you get an idea about what is actually mentioned. Judiciary, there shall be a Supreme Court consisting of Chief Justice and okay, and until Parliament by law prescribes a larger number of not more than 7 judges. Okay, minimum is 7 as provided by the Constitution, but Parliament has made a law and it has been amended therewith from, okay, a Supreme Court number of judges act. So that is the act which governs the number of judges in Supreme Court. So CJI shall be consulted, and all these are fine. 5 years as a judge of Supreme. This is the eligibility conditions which I have already discussed. Judge of Supreme Court shall not be removed except by an order of the President, passed by an address of each House of Parliament. So this is also something which has been discussed. Parliament may by law regulate the procedure for presentation of an address and for investigation of judges. Okay, that is why we have the Judges Enquiry Act. Parliament has created by law. So what if I ask you a question? A constitutional amendment is required to change the number of judges of Supreme Court. I'm sure you know, you'll be able to answer it right now. But this can be a potential question. Okay, a constitutional amendment act is required to change the number of Supreme Court judges. I'm sure you can answer it now easily, but because you know the constitutional provisions. Okay, let me ask a different kind of a question. A constitutional amendment act is required to be passed under procedure given under Article 368 for amending the provisions of 5th schedule of the Constitution. Do you know what is the 5th schedule of the Constitution? I'm sure many of you would be knowing about what is 5th schedule of the Constitution. Do you know about it? What is the 5th schedule? Yes, it deals with scheduled areas. My question is, if you want to change the provisions in the Constitution with respect to, if you want to make amendments to 5th schedule, is a amendment act under Article 368, is it necessary? Okay, the answer is yes, yes, no, no, not required. Why do you say it's not required? No, sir, I think governor can do. Okay. Simple majority, yes. Not related to federal provisions. Very good. So that is the answer. Basically, it's not just because it is not related to federal provisions. Did I tell you about constitutional amendments? Amendments can be done by a simple process. It can be done by a difficult process. And when I discussed about simple process, did I tell you those parts of the Constitution where the Constitution itself has given that these parts can be amended by an ordinary law of Parliament? Wherever it is given so, those areas can be amended by a simple process. You don't have to follow the procedure under Article 368. And I had given you an examples of what those areas are. Article 3, talking about incorporation of new territories, changing the boundaries of the states. It's explicitly given in Article 3. Parliament by law can merge 2 or more states, all that, right? Similarly, when you read the 5th schedule provision, it will be given in 5th schedule itself. An amendment to this schedule can be done by an ordinary law of the Parliament, and it will not be deemed to be an amendment under Article 368. So that is why. So you just have to be very clear about what all areas of the Constitution can be amended just by an ordinary law, where you don't really require a Constitutional Amendment Act to be enacted. Okay. So similarly, now you have an idea that Supreme Court's number of judges can also be amended without a constitutional amendment. Can be done by an ordinary law of the Parliament. All right. Okay, salaries, all that has been discussed. Okay, this is about appointment of acting Chief Justice. Okay, it's very simple. If the Chief Justice of India is not he's sick, he's not able to discharge his work. So President will appoint one among the other judges as acting Chief Justice. Okay, until the Chief Justice gets well. Okay. Okay, these are two different concepts: appointment of ad hoc judges and temporary judges. So there are two concepts here. I'll just explain to you after some time. Okay, I'll just explain to you after discussion of Supreme Court. Other provisions. Okay, let me ask you another question. So contempt of Supreme Court is something which has been recently in news. Will you agree or not? Yes? Even today or yesterday, there was issues about Justice Karnan related contempt issues. Even quite a few months back, there were issues regarding Prashant Bhushan's case. These are all cases involving contempt of court. So, the power of Supreme Court to punish a person for contempt of Supreme Court has been defined in a statute. Will the statement be correct or will the statement be wrong? The powers of Supreme Court to punish for its contempt is a power, is a statutory power. Okay. Yes, Constitution gives it, but even a statute also gives the power. Constitution does not talk about what will be the punishments. Constitution only says Supreme Court can punish a person for its contempt. Okay. Supreme Court shall be a court of record and shall have the powers of such a court, including the power to punish for contempt of itself. Of course, Supreme Court has been given the powers to punish, but what would be the quantum of punishment is something which has been decided by the law. What all would amount to a contempt of court? Contempt is a broad term, right? So that is why we have a separate statute which is called as Contempt of Courts Act 1971. It is that act which talks about what all can be classified as contempt and what would be the punishments. So yes, I did not say it is only a statutory power. I said it is also derived out of a statute. So that statement is not wrong. Yes, it's constitutionally a power has been given in Supreme Court to punish for its contempt. I would not disagree with that. But in addition, also know that what are the punishments, what is civil contempt, what is a criminal contempt, all that is not defined in the Constitution. It is actually a provision given from an act which is called as Contempt of Courts Act. Okay, I'll explain contempt in detail. For now, let's just continue forward. So Supreme Court can also sit in any other places. President will decide that. Okay, where usually it will be in Delhi, but at any point of time, the seat of Supreme Court can be shifted to other places also. These are all just constitutional provisions, and this is what is original jurisdiction. I have just asked you, I had discussed with you about it. Okay. This is about appellate jurisdiction. Yes. An appeal shall lie to Supreme Court from any judgment, decree or order of a High Court in the territory of India, whether in a civil, criminal or any other proceeding, if the High Court certifies that the case involves a substantial question of law as to interpretation of this Constitution. Okay. Normally, Supreme Court will not, High Courts will not give the certificate of fitness. It is only if there is a complicated matter in that particular case. Okay, what is called as question of law. Question of law and question of fact. There are two different concepts. I'll just explain to you what is this difference. Question of law, question of fact. So let's consider I take a revolver and I just fire at a tree. There is a bush in front of me. I just fire at the bush. Okay. So the bullet goes and it hits the person on its head and the person dies. Okay. I'll just in a very simple manner explain to you what is the question of law and what is the question of fact in this particular issue. Whether the bullet had killed that person or not. Can you answer in yes or no? Is it possible to answer this question by using yes or no? Whether the person died because of the bullet injury or some other reason. Can it be answered in terms of binary yes or no? What is your answer? It might also be in the case where I just fired a gun and the person got scared and he fell down or he had a heart attack and because of that he could have died, right? So okay, just to clarify, simple majority is required to change the total number of judges from 31 to 34. Yes, a simple majority. So this is a binary question. You can find it out from post-mortem report. Whether the bullet wound was the reason for blood loss and because of blood loss the person died or not. It's a clear association. You can decipher it from post-mortem report. Okay. So this is a question of fact. What is this question of law? What was the intention behind my action? What was the intention in firing? Was it an accidental firing or was it a firing that I did for controlling the crowd in that area, or was it my intention to murder him? Yes. These, can you answer these in yes or no? These are the questions where you cannot actually answer in yes or no. It needs examination of evidences. It needs a careful construction of the scenario, what has happened, right? To find out the intention is not as simple. These are what are called as question of law, because if it is a firing that was done with my intention to murder him, it's a different section of IPC that will be applied. Whereas if I had fired that gun, but I did not have, my intention was not to murder him. It was just to, I saw a bush and I fired it. It was, I did not even know that there was a person behind. Okay. So that is also a homicide, but it is not a murder. A murder is different from a homicide. Okay. Homicide means the death of a human being. But my intention was not to murder him. So what was my intention? Finding out the intention is not as simple. So it is these kinds of questions which are called as question of law. Okay, question of fact are straightforward, whether you have a particular thing or you don't have a particular aspect. But finding out what was your intention are different aspects. So it is only when there is a question of law involved in that case. The judge feels he's still not able to convince himself that he has correctly identified the intention. With all circumstances and with all the evidences produced before him, the judge is of the opinion that his intention was to kill. But still, he himself is not convinced whether it really was an intention to murder or not. So that questions will be called as question of law. Okay. So that's why that is in such kind of cases where there is a question of law, where the judges feel that it is not about whether the bullet was the reason for the death or not. That is not the question that needs to be appealed before the Supreme Court. It is more about the intention of the person. He says that I did not have any intention to murder that person. It was just an accidental firing or something like that. So such questions will be called as question of law. Anyway, as I just want to emphasize that again, these also will not be asked in the examination. But just because the terminology is there in the Constitution, you just have to know. Question of law means the judges have to seriously apply their mind. It requires higher level of intelligence. It requires a lot of brain to think on such kind of area. So the judges feel better judges are sitting above me in the Supreme Court, and let them dispose of these issues. Okay. So basically, you just need to have the High Court's fitness certificate that there is a question of law. So please take up the case and hear that case. Okay. So involves a substantial question of law of general importance. In the opinion of High Court, the said question needs to be decided by the Supreme Court. This is what I was actually explaining to you right now. This Parliament, okay. So this is what I had told you, where a High Court will withdraw the case that is pending in Sessions Court. It will decide itself and it will give a death punishment. In those cases, yes, you have an appeal in Supreme Court. This is with respect to criminal matters. What I have just shown you here is with respect to civil matters. Okay, we have two different articles. Article 133 deals with appellate jurisdiction of Supreme Court with respect to civil matters. In civil matters, there is no right of appeal in Supreme Court. Okay, appeal is only possible if there is a great question of law that needs to be decided. Okay, unless then there is no right of appeal for any person to Supreme Court. It is only if a High Court decides that yes, you still can go to the Supreme Court, you have that. There is no right of appeal. Okay. This is with respect to criminal matters. Jurisdiction and powers of federal court under existing law. Okay, this is nothing. This is just before the commencement of Constitution. Whatever was done by the Federal Court of Justice, it will be done by Supreme Court. That's all. There is nothing significant about it. Another jurisdiction of Supreme Court is special leave to appeal. I'll explain to you what this is. So two aspects I'll have to explain to you. One is with respect to powers of contempt of Supreme Court. The other one is with respect to special leave to appeal. I'll explain to you. But before that, let me complete this review petition. Yeah, the purpose of showing the Constitution is to point out where is this review. Can anybody help me in finding out where is the power of review given? It is somewhere given in the Constitution. I'm just not able to spot it exactly. Article 137. Okay. Yeah. Article 137 says, subject to the provisions of any law made by Parliament or any rules made under Article 145, the Supreme Court shall have power to review any judgment pronounced or order made by it. So power has been given in the hands of Supreme Court to review its own decision. So how is this process done? For that purpose, Supreme Court has made Supreme Court rules, SCR. Wherever you come across this word, it refers to Supreme Court rules made under Article 145 of the Constitution. This is the rule-making power of Supreme Court, how it should govern itself. Okay, so based on the rule-making power, Supreme Court has further made rules on how should a review petition be filed, how should a review petition be treated, how should it be disposed. All that Supreme Court has made separate rules. So what is this process of review? So let's say 3-judge bench had heard, they had upheld death. They say that yes, death punishment is correct. Okay. It was decided by a bench of 3 judges. 2 of them, they said death, whereas 1 judge, he was not in favor of awarding the death punishment. He felt that this is not such a severe case that death punishment has to be given. This is a case for which even life imprisonment would be good enough. Okay. Why did this judge come to this kind of a conclusion? Maybe because during the time of arguments, when the lawyer was presenting his arguments, this one judge, he was able to find certain reasoning. He was able to find certain arguments which he felt was convincing enough to decide that death is not necessary. Okay, let's say the lawyer, he makes a very strong argument. He says that the person was actually drunk. So in a drunken state, he was not able to actually realize. He was in a semi-drunk state. So in such a kind of an inebriated condition, this man had taken the knife and he had stabbed. Okay, so you cannot actually give him death sentence. The lawyer pleads, and this judge is convinced that yes, maybe the person was not really in his senses. He was not conscious enough to make a very conscious choice. So I cannot actually give him death sentence, so let him be given life imprisonment. But the other 2 judges, they felt no, death sentence. So it means that even among the judges, there was a different kind of an interpretation that was possible. Okay, the other judge, he had looked into issues which the other 2 judges were not able to appreciate. If these judges can also be convinced to appreciate the other point of view, so in that case, there is a possibility of the person not being put to death, because once you put him to death, there is no relief after that. And but an Indian judicial system is not focused on vengeance. It is not focused on retribution. Okay, what is retribution? Eye for an eye. You kill me, I will kill you. That is not the objective of our criminal justice system. And do you know what is the objective of a criminal justice system? Is it to punish a person? Is punishment for the sake of wronging a person who has done a wrong? Is it for that purpose we have the criminal justice system, all this judiciary, laws and all these things, prison? Is it all for the purpose of retribution? Retribution is to seek revenge. It is to punish him for what he had inflicted on others. Yes, our criminal justice system is based on reformation. Okay, what do I mean by reformation? The person is consider this entire system as a human body. If you have a disease in your hand, will you just cut it and will you throw it away? Will you just cut it and throw it away because the hand is diseased? No, you will try to treat it. You will try to cure the problem so that the hand can become functional again. The hand can also contribute to the well-being of this body, correct? So that is how you treat a disease. Similarly, the accused, a murder accused, is a diseased person of the society. You have to change him. You have to reform him. You have to reform him and once again bring him as a part of the society. Okay, it is with this concept our criminal justice system functions. It is only when there is a cancer growing in my hand, the cancer is not treatable. In that case, I'll cut this hand and I'll save the rest of the body. It's the same case with criminal justice system. It's only when a member becomes too deviant, he can never be reformed. All hope is lost. He is a serial murder killer. If that is the case, in that case, he can never be accommodated back to the society. Then he should be dispensed away with, right? So our usual criminal justice philosophy is that as much as possible, make an attempt to reform the person and bring him back to the society. It is with that kind of a guiding principle our entire criminal justice system works. Okay, so in that case, if at all there is even the slightest possibility of once again convincing the judges, that should be used, and that is precisely why we have the review powers given in the Constitution, the Supreme Court itself. Normally, for all cases, the Supreme Court will not review its own decision. It's only when it comes to death punishments, Supreme Court will even entertain a review petition. A review petition, how it should be filed, within how many days it should be filed after the judgment, all that is provided in the Supreme Court rules. Okay, Supreme Court provides a maximum timeline of 30 days after the judgment. After 30 days after the judgment, you can file a review petition. But if there is a delay, still Supreme Court itself can decide, okay, the delay is accepted. Usually, Supreme Court gives a time of 30 days. Within 30, you'll have to file a review. And to file a review, it should be filed by an advocate on record. That is, a lawyer with a considerable experience. Not fresh entrants, fresh lawyers, junior lawyers. They are not in a position to ask the judges to once again review the judgment, right? That is why senior advocates, basically the ones who are termed as advocates on record, it is that category of advocates who can file a review petition. They will say that because of my experience, rich experience in law for 10 years, 15 years, I am filing a review petition, praying the honorable judges to once again have a look at the judgment that has been delivered. Because I find there is a slightest possibility that this death punishment can still be changed to life in prison because there are certain grounds. He is not someone who had committed the crime intentionally. So please once again be kind enough to review your judgment. A review petition can be filed. Okay. And the review petition will be filed before the same judges, the same 3-judge bench who had given the judgment. It is to these judges a review petition will be actually filed. So most probably, so do you think the judges will be forthcoming to accept the review petition? At least if it's a different judges, then you have a hope. Oh, yes, they may think that the other judges have not used their mind and maybe they can have a different interpretation. But the same judges, why would they accept a review petition? So that is why, if at all the review is denied, if at all these judges are not convinced that I am not going to review my decision, even then not all hope is lost. There is still one more last avenue, which is called as a curative petition. Curative petition is a result of Supreme Court rules. Supreme Court has created rules for the purpose of accepting curative petition. And what is the purpose of curative petition? Basically, if a review petition is dismissed, the lawyer of the accused, so he can still go and convince the senior-most judges, 2 senior-most judges in Supreme Court, they will be filed a curative petition. Okay, so if the senior-most judges of the Supreme Court, if they decide, yes, the lawyer has a point, there is a strong ground for reviewing the judgment. If they are convinced, in that case, yes, once again, a review will take place. Okay, So that is what is called as curative petition. So this is all about the power of review. It is only after a review is rejected, after curative petition is rejected, only after that a person files a mercy petition before the president. Okay. After exploring all options, the person goes for filing a mercy petition to the president. So this is all about the power of review given in the hands of Supreme Court. Let me discuss about the other powers. The power of punishing for the contempt of the court. Why do you think a court should have the power to punish for its contempt? Why? Why, in your opinion, do you think a court should have the power to punish for contempt? If somebody insults a court, the court should be in a position to punish, right? Why? Why do you think so? Okay, it may reduce the confidence of people on the court to ensure supremacy of judiciary. If the case is against the arbitrary action of executive fails to obey, the court should have. I think you guys are already, you have brought in all the answers to not let people view judiciary in a bad taste, to protect its integrity and superior office. Such a thing is not there. Everyone will start blaming or criticizing even for small things. Correct, correct. All points have been brought out. It is basically to reinforce the trust of the common man on judiciary. You cannot allow unnecessary criticisms on the court. Then people will stop trusting the court of law. If they feel that even court of law cannot provide them justice, people will start taking taking law in their own hands. It's only when they have the trust that there is someone to decide in a neutral manner, people will be law abiding. If they lose that trust, after that people will civilization will collapse. We'll all get back into jungles once again. So it is to prevent all that from happening. The court has been given the power to punish for unnecessary insult or lowering the dignity of the court. If anybody involves in such activities, they have to be punished. Okay. And who would involve in such activities? The government itself, executive, can involve in such activities. The common man can involve in such activities. Okay. So that is why, because if executive wants to punish a person, it always has the police force. It can go lock them up, beat them. It can safeguard itself. The government can safeguard itself with its police force. The legislature also has the power of punishing for its contempt. We have what is called as parliamentary privileges, correct? At that time, we had discussed that the power of punishing for its contempt is given in the hands of the legislature. But for the judiciary, they are judges who are sitting in a room and they are discussing about what needs to be, what is the right and what is wrong. So to protect themselves, the Constitution has given this power to punish for the contempt of the court. Okay, so that is why we have these provisions. Yes, a common man like Prashant Bhushan or Kunal Kamra tweets that scandalizes the court. Of course, you have to protect the dignity of the court. It is for these reasons you have the power to punish for contempt. Does anybody know what is the difference? There are two types of contempt. What is called as civil contempt. The other one is what is called as criminal contempt. Do you know what is the difference between the two? And these two contempts are not given in the Constitution. It is given in the Contempt of Courts Act. Contempt of Courts Act talks about the two different kinds of contempt. Anybody? Do you know what would be the difference between the two types of contempt? Civil contempt. This is what many officers, once you become a sub IAS officer or IPS officer, many a times you will be called to the court. Okay. So when I was on the field as a sub collector, I was summoned to the court. So High Court had issued a summon for contempt of court. I had to go and make an appearance before the court and give an explanation. It was basically an order that was given to my predecessor. Okay, court does not care about the person who has committed the contempt. Court only cares about the authority. The earlier sub collector, during his tenure, he had done something or he had not done something because of which he had incurred a contempt of court. So he did not make an appearance. So when I took charge and I was summoned to the court, then I had to give an explanation that I had only newly joined. So I was not even aware that this particular issue even exists. I'll ensure that it is completed within a span of time. Then the court will issue me directions. Yes, complete the task within 20 days, within 10 days. Okay, so civil contempt means not obeying the directions of the court. Do you know that recently a collector in Andhra Pradesh was ordered to be imprisoned for contempt of a court? Do you know that? Have you come across that news? A collector and one more officer, both of them were ordered to be imprisoned. Yes, because of such kind of contempt. Officers will not indulge in these activities. They will only indulge in these activities. The field situation is completely different from what the court orders us to do. So there are times when you may incur the contempt of court, civil contempt of court, because you may not be in a position to implement such orders, right? So this would amount to civil contempt. If you are willfully, if you are disobeying the directions of the court, if you are not taking the actions that the court has asked you to take, you incur what is called as civil contempt. Okay. What would amount to a criminal contempt? Criminal contempt is so you have a criminal intention behind your actions. Okay, it is to defame the judges. It is to take people inside the court and prevent the judges from doing their work. So how many of you have seen this movie released in 2020, the Chicago trials? Have you seen that movie? It's a very good movie, Hollywood movie. I think it has been nominated for Academy Awards also. Some 5 nominations or something have been made. Okay, it's a very good movie, and if you are interested, if you have free time, which you will have in plenty, you can try to watch that movie. Okay, Chicago Trials. So that movie entirely revolves around this concept of contempt of court. Because in our movies, no, they don't really show this how this contempt is incurred. They don't actually show in any of our Indian movies. Okay. So obstructing the court. What do you mean by obstruction? The judge is saying you sit down, you are not supposed to talk. Okay, all hearings in a court is done in an open court. That is, what do you mean by open court? Each and every judgment must be passed in an open court. People should be made a party to the judgments. Anybody can come and enter into a high court or a supreme court or a district court, and you can observe what is going on and you can be a party to the judgment. Okay, the purpose of this judgment being given in open court is justice should not only be seen to be given, justice should not only be given, it should also be seen to be given. Okay, people should believe in justice being given. And how would they believe that quality justice is given? It's only when they can see what justice is being done. So that is the principle, and that's why we have this open court concept. So people come and sit on the day of hearing, and when the judge, somebody is shouting in the court, and the judge says, please sit down, you're disturbing the court. If you repeat it, I'll imprison you, I'll punish you for contempt. But still the person is shouting, he's keeping on shouting, so that court work is not being able to be done. Okay, so that would be a willful, what do we say, that's a clear case of obstruction of the court work, obstruction of justice. So that would become a case of criminal contempt. Okay, and the other kind of manner in which you can incur criminal contempt is if you scandalize the image of the court. That is, you write something rubbish about the judges. I can give you an example of obstructing the court. This is exactly what Justice Karnan, who was a Madras High Court judge, he did that when he was a Madras High Court judge. what happened was, one day the Chief Justice of Madras High Court, he was holding his court. He was proceeding with his court work. So he was proceeding with his court work. Suddenly, Justice Karnan, who was also one of the other judges of Madras High Court, he just came running into the Chief Justice's court, and he started shouting at the Chief Justice. Okay, another judge of the Madras High Court, he is entering into the court of Chief Justice of Madras High Court, and he is shouting that you have not recommended my name to be elevated to Supreme Court judge just because I am a scheduled caste person. Okay, maybe there is a truth in his statement. Looking at the composition of the Supreme Court bench, there is definitely a truth in his statement, but he was shouting, and finally the Chief Justice got really angry. So he wrote a letter. He wrote a letter to Chief Justice of India asking Justice Karnan to be transferred from Madras High Court. Okay, he felt that he is becoming an obstruction to all of us, so he should be immediately transferred from Madras High Court. So immediately the CJI, with his collegium, he was able to get that judge transferred from Madras High Court. He was transferred to Calcutta High Court. Okay, and when he was a judge of a Calcutta High Court, what he did, he suo moto, he took up a case of untouchability against the judges of Supreme Court. The judges of Supreme Court who are in charge of collegium. Okay, so he himself initiated a case. He suo moto took up that case in his court as a judge of Calcutta High Court, and the case was under Prevention of Untouchability Act. And Justice Karnan gave a verdict that these judges of collegium, they are practicing untouchability against me. That is why I am not being elevated. So I am ordering the judges to be imprisoned under Untouchability Act. This was the verdict that he gave. Immediately, the Supreme Court judges, they initiated contempt proceedings against him. They said that you are scandalizing the image of the judges with a purpose to lower the dignity of the court. So hence, they started a criminal contempt case against Justice Karnan, and Justice Karnan was ordered imprisonment. Okay, so Justice Karnan then immediately fled away. He ran to Nepal. He took refuge in Nepal. Then after coming back, he himself gave his resignation and he stepped down, after which he served a jail sentence also. So he was put behind bars for 6 months, I think. He was given 6 months imprisonment by Supreme Court. So this is all that actually can happen. Justice Karnan had involved in both these acts. One is obstructing the court, the other one is scandalizing the court. So obstructing is you interfere and disturb the court work. Scandalizing is you cast a negative character, negative image on the judges and the Supreme Court. So this is what will come under the definition of criminal contempt. Okay, and that is exactly what happened with respect to Kunal Kamra, or Kunal Kamra is just tweeting Prashant Bhushan's tweet against the Supreme Court judges. Do you know what happened in Prashant Bhushan case? That is a recent case. Markandeya Kajju's controversy. What happened to Markandeya Kajju? Did he do anything? He himself was a judge of Supreme Court. So what did he do? Did he do anything that can be called as contemptuous of Supreme Court? Did he do anything like that? I'm not aware of that. Prashant Bhushan's case. Do you know what happened in Prashant Bhushan's case? The Chief Justice of India, Bobde, he went to Nagpur. He is a man of Nagpur. Okay, so he went to his hometown. Yes, CJ Bobde bike. So he was anyway known to be close to political circles. BJP political party, he is known to be close to them. So there was a BJP MLA in Maharashtra. So his son had a Harley Davidson bike, and CJI Bobde, so he is a lover of bikes. He has a lot of super bikes in his home, in his collection. So he took a photo sitting on the Harley Davidson. Okay. So immediately Prashant Bhushan tweeted, if this is the behavior of Chief Justice of India, what kind of justice will the court be able to give? Okay, so he made some kind of statement against the Chief Justice. So immediately the Supreme Court took up this case as you are scandalizing the image of the court. And they went on, the case was heard. And finally, Prashant Bhushan was given a punishment. The punishment was you pay 1 rupee fine. Okay, it was a token punishment. The court, after starting this contempt process, the court became the object of ridicule. Okay, this is not the days where social media is not present. These are days where social media is very active. So people started criticizing the action of Supreme Court. First of all, he should not have sat on the bike. He should not have showed himself as closer to political party. After doing that, there are so many of us who have tweeted against this particular act, and only Prashant Bhushan is being targeted, and now it's becoming blown out of proportions. Okay, in the sense everybody starts criticizing the Supreme Court. Now, Supreme Court, by starting this criminal proceedings, contempt proceedings against Prashant Bhushan, has now become an object of ridicule in the eyes of the entire general society. So, how many people will the Supreme Court go and punish? That is why Supreme Court wanted to come out of this muddy issue. Supreme Court, it found a compromise. It said that I cannot just allow you to go free. If I allow you to go free without giving any punishment, that would become a wrong message. Everybody will start criticizing us. So I am going to punish you, but at the same time, Supreme Court also understood that if it gives a very excessively harsh punishment, once again it will become an object of ridicule. So that is why it wanted to find a way out of this entire episode. Supreme Court gave a very token punishment: pay 1 rupee as a fine. Then Prashant Bhushan was thinking, should I pay that 1 rupee? Okay, if I pay 1 rupee, in that case, it would be like as if I'm accepting my mistake. If I don't pay 1 rupee, then I'll be put behind bars. Then Prashant Bhushan also thought, okay, I'm anyway very old, and why should I spend 6 months in jail? Anyway, I have won this case morally. The entire nation has turned against the Supreme Court. So the Supreme Court felt, so Prashant Bhushan felt that let me not take this episode, prolong it further and further, and so he decided I'll pay 1 rupee. And even after paying 1 rupee, he thought that should I go and file a review petition? Okay, so even he was contemplating a review petition, filing a review petition also. But anyway, I hope I can bring in the point that the power of contempt available in the hand of Supreme Court should be rarely used. It should be sparingly used so as to protect the institution only when it is genuinely under attack. It's the courts themselves, the judges themselves, whose conduct should be above suspicion. If they allow their conduct to be questioned, in that case, the contempt powers would also not be sufficient enough to protect the court. There is a limit, okay, which the Supreme Court itself has to fix, and it should not transcend beyond those limits. So, my question is, these are the idea behind the power of punishment for contempt. One question that I can think about as a potential prelims question is the permission of Attorney General of India necessary to punish a person for the contempt of a court? Is it necessary or is it not necessary? Not necessary. Well, the answer is it is necessary, and sometimes it is not necessary. So when it is necessary and when it is not necessary. If someone obstructs the court, someone is in the court and they are obstructing the court, in that case, the consent of the Attorney General is not necessary. The court itself can directly proceed against him and can punish him for contempt. But in cases where a private person, I am a private person and I feel Prashant Bhushan's tweet against the judges is offensive. If somebody else, if a private person wants to file a contempt case against another private person before a Supreme Court, first he has to go to the Attorney General. Attorney General should give his consent. Yes, this is a serious assassination of the dignity of the court, and only after that a contempt case can be filed. So if the court wants to take suo motu cognizance of a contempt issue, the court can take on its own. But if a private person has to file a contempt case, it has to first get the consent of the Attorney General. Only then can a contempt case be filed in a Supreme Court. Okay. The power of contempt, punishing for contempt, is a power given under Contempt of Courts Act for both Supreme Court as well as High Court. So understand, High Courts also have the power of punishing for its contempt. Just like how we have an Attorney General in the Union, even in the state government level, you have an authority who is called as Advocate General of the state. He will be the chief legal advisor to the state government. So under Contempt of Courts Act, if a person has to file a contempt case against the court in a Madras High Court, then the same process has to be followed. You have to first go and get the consent of the Advocate General of the state, and only then you can file a contempt case in Madras High Court. But if the court would want to take suo motu cognizance of a case, there is no need for consent or anything. Okay. So this is it. We'll just take a break, a 5-minute break, and then we'll continue. Okay. ஹலோ. நல்லா இருக்குமா, சொல்லுங்க, என்ன விஷயம்? Sir, okay, there's a question which has been asked. Just out of curiosity, you cleared the exam, then what are you doing in Shankar? You quit the service. Yes, I had quit the service. So I cleared this exam twice. Okay, I mean, I'm just surprised with this question because I thought you people knew about me already. Okay, even if you do not, I had cleared this exam twice in 2013 and 2014. Then I was working for five years in government. So I was working for 1 year as assistant commissioner in income tax, then 4 years in various capacities as an IAS officer. And 2019, I resigned from the service. And since then, I'm teaching here at Shankar. Okay, I know, I can understand the next possible question also you would be asking. And the next question is it the norm that review petition is to be heard by the same bench? Yes. Supreme Court rules say that the review petition should be filed before the same group of judges who have delivered the judgment. It's not a norm, it's the rules. Supreme Court rules say so. So that's all. This is all about the contempt procedures, contempt powers. Okay. Why, sir? Okay. Did I already give this answer to this batch, or have I not answered this question to this batch? Or no, not yet. Okay. I believe I have answered. No. If it, okay, not yet. Okay. No, sir. Okay. Still a mystery. Okay. Reason was not given. Okay. We'll have a very casual conversation then. Why? You tell me, why would a person quit a service? What would be your imagination if I would not were to give if I were not to give my answer? Can you just think of some reasons? You can just type in whatever comes to your mind. Okay. Okay. Political interference. That is not the answer at all. I would not say. Okay. I would not say political interference is not at all, and it's not okay. It's something which I had already known before even getting into the service. And moreover, what do you mean by political interference? It is the politicians' work to interfere. Okay, that is why they have been elected, to make sure the administration is running properly, to make sure people's problems are brought to the knowledge of the sub collector or to the collector. Politicians interfere with a strong reason, with a good reason. They are not bad guys all the time. Okay, politicians have their own compulsions, the compulsions to satisfy the expectations of their constituents. So they are not inherently bad or something that they would make your life miserable. Not at all. See, the system works on some kind of an understanding. This is the bureaucrat's job. This is the politician's job. Why would a bureaucrat try to be a politician, or a politician try to interfere in the work of a bureaucrat? No, they would come with a lot of impossible expectations, illegal expectations. but it is your job to say that no, I will not do it, and you are always at your liberty. You are free to say so. Okay, so it's not such a black and white question that politicians are bad and IAS officers are the good guys. No, I would not accept such a view. So uh, it's 0% political interference in my case. I was very clear about what I was doing. Politicians would also not interfere with you if they know that you are this kind of a person. Okay, it's only when they know that you are someone who would take a bribe, who also would like to dabble in petty politics at the local level, then they would come to you knowing that you can get some things done, knowing that money can get things done from you. Okay, otherwise they will not disturb you. They are also good people. Okay, so I wouldn't say political interference is the reason why officers quit. Even the Santosh Babu, this IAS officer who had quit, no, Tamil Nadu secretary to a department, quite a senior officer. So he did not face any political interference. See, his honesty was not acceptable to the system. He came up with a very good tender scheme. So he cancelled some tenders which were not done following proper procedures. That is his job. He can do that. And understand he has the liberty to do that. Such a multi-crore contract, he has the power to cancel it. Okay. So then why would you even think that there is political interference? There is no interference. Politicians would always want to get some kickbacks in whatever money is being spent. I can say that I have a honest approach towards things being a non-politician, but I would not know if I would be in a position to be honest if I were a politician. Okay, because you have a lot of political expenses to be satisfied. Of course, there is a lot of greed also involved. The politicians come to power just to fatten themselves. There are other issues, there is no doubt about that, but he did not have any interference. So he was able to do his work, but he felt that he can do something better. See, both are two different jobs. The work of a politician is to represent people. It is to represent people's problems. So it is to decide what is necessary for the people. It is a bureaucrat's job to get these things done. If politician decides free Wi-Fi connection all across Tamil Nadu is our priority, that is the work of politician. He will decide what is good for the people. A bureaucrat's work is to tell him how to get this thing done, how to do, what are the procedures that needs to be followed, who should be roped in as suppliers and contractors, what is the timeline. So you are basically a planner and a manager. So there is no conflict of roles or anything. In fact, both of them are assisting each other in taking the nation forward. Okay, so there is no interference. Of course, when there will be interference, but whenever there is interference, you can always stand your ground and you can always maintain who you are. Okay, so don't think. I think Shankar sir's death might have affected you, sir. No, nothing to do with death of Shankar sir. Nothing to do with that. Okay. In fact, Shankar sir's sister was my collector. I was the sub-collector in a subdivision where Shankar sir's sister Brinda, she was my collector. And I had nothing personal with Shankar sir, anything. Okay, but I had this mindset of quitting IAS the very day I entered into the service. Okay, not very day. After some time, I started getting this feel. Even before meeting politicians, I had started getting this feel that I should do something else. No, if it's about cadre, it's not at all about cadre. It's not at all about cadre. Okay, if it's about cadre, I can even give my attempt now also. I still have 6 more attempts to give. So I can give attempts and I can once again get into IAS if I would want to get into. So even cadre is not an issue. I think it's more to do with my personality only, I can say. I still cannot find a planning to jump into politics. No, I would not do that. Okay, no, not at all. Politics, again, my satisfying answer, which I have found for my own purposes, I'm not able to spend time on my interests. So that is the honest answer. That is the honest answer. It's not complicated beyond that. Okay, so I felt I'm just working there for the salary part and okay, larger public interest, taking care of the good of the society, all that is there. And it's no, Odisha may be a poor state, but it has a very rich facilities for the officers. Odisha cadre, there's nothing wrong about the cadre as such. Yes, it's an underdeveloped state. There is nothing much, no entertainment in lives. It's all jungle all the time. You will only be roaming in the forests all the time. But perks and privileges wise, there is nothing wrong about any states. Every state knows how to take care of their officers in the best possible manner. An IAS officer, even in Mizoram, is an IAS officer. He enjoys all kinds of perks and privileges. Same. So it's not about the creature comforts or the privileges or the facilities that make someone quit the service or anything. There's so many other reasons also. Okay, but it's not the reasons which normally you would think. That is not the reason, because people are very different, right? Each person has a different taste, different opinion, different orientation, different ideas of how they should live their lives. Correct? So, okay. So I would say, so I'm, so I. It's just me. That's all. Okay. There is no other explanation. I just felt I'll do something else in my life. That's all. There are no other complicated reasons which should make you wonder if I should clear this exam or not. If you have, okay, I hope nobody is having such kind of mindset, right? Nobody has the mindset of, oh, should I enter into civil services with people coming out of it? Should I enter into civil services? Yes, I am also an engineer from CEG. That's correct. Okay, I have definitely not. And for those who have, don't have that mindset. This is the best possible position in the world, not just in India. Not just because I happen to be in this business. Okay, it's not for that I say this, because no other bureaucracy in the whole world takes you to such high positions with the one single examination. That is the truth of civil services across the world. Everywhere you have to start from the lower levels and fight your way up to reach the top. But here, this is like a quantum jump that you get if you the minute you clear this examination. Okay, so you do not know about what good lies once you get into the service. You would not know it as of now. It's only when you start becoming a part of that you will understand that. And morally, I did not have any dilemmas or any pressures. It was all very clear to me. Okay, so I never had this ethical dilemmas or moral dilemmas. So that was not a reason for why I would have to quit the service. So I just wanted to come back to Tamil Nadu. That was one other main reason. I wanted to come back here, and I felt that the job that I was doing in the IAS is something which everybody can do. Anybody who clears college level, I think people can just do the job. The civil service examination is tough, but the work of an IAS officer is not a tough work. It's a very simple work. It's a common sense related work. Anybody with a working functional literacy with decent level of analytical skills will be able to completely do a very good job in the as a role of a collector or as any IAS officer. Okay, so that's why. So I was not feeling very interested also to do the job, but it's just me. Okay, I wouldn't say the job is boring. At times there were so many interesting things which have happened in my career also. It's not that the job is boring or anything, but a lot of time will go on routine work. A lot of time will go on routine office work, because government is a stable machinery. Okay, government is not a innovator. It's not a science lab where you create new things every day. No, it's a stable machinery, a status quo machinery. You have to keep that machinery running as a IAS officer, and the process of keeping the machinery running, very few instances of what do I say, of some very few instances of what do I say. So it's not just suiting me, okay, but let me tell you, if you are interested in, but I have gained a lot from civil services. Okay, the kind of social status, I don't think I could have ever got it in any other profession. First, most important, non-negotiable. No other profession. You may be the general manager of some Reliance also, but still no. This is something different. Okay, so we work in a society, so definitely that social upliftment or social status that you immediately gain recognition from the people, that's completely unparalleled when you compare it with any other services. First, job security, another, and work-life balance. No problem in bureaucracy. Perfect work-life balance. In fact, I have to work more here compared to the work that I used to do as an officer. As an officer, I don't have to go to my office at all. Okay, no, never. Even if I don't go to office for 1 month, nobody can question an officer. The reason is because I was not very keen on spending my time in the office. So what I'll do is, morning I'll get up, take my vehicle, go on trips all across my subdivision. I have just covered all remote possible areas of my subdivision. I just like to go on tours, find out how offices work, find out if people are coming regularly or not. So that was the interesting part on a daily basis. But once you come back to the office, then it's routine work. You'll have to send correspondences to the other higher officials. You'll have to deal with inter-official office communication. So all those aspects. Okay. So what I'm saying is, that is a job where you will never be questioned. So it's up to you. You can choose about how you should actually do your work. Even if you don't do your work completely, it's chill at your home. You will have. I used to have six people always in my home to take care of my work. Okay, there will be three peons, two security guards, and two cooks, and there will be one driver. There was one more driver who, because I had additional charge of a municipality, so I was having that driver also. Always you'll be always surrounded by a lot of people all the time that's a very royal life. Okay, so you will never ever get it elsewhere. That's something which I can give you for granted. You may have working servants in your home, but servants are different from your resident personnel. They are different. They are a different category. So the minute you leave the house, all of them will come and stand in attention before you. Come at attention. So they'll be very, very respectful. They'll stand before you. They will see you off. So by the time your vehicle approaches the gate, you as a field officer, as a sub collector, or as a collector, or as a CEO Zilla Parishad, these are the field postings. You will usually be given a bungalow residence. Okay, my residence was around 3.5 to 4 acres. That was the size of the residence. That's why you have to always have some gardeners and all these people here. By the time they see a vehicle from a distance, so that's like an exclusive road for 200 meters. Only my car will go on that road. Okay, so that was the size of the campus. So you go there, there'll be two gates, one for the inner house, one for the outer compound, periphery. The outer gate will open, and these guys will immediately come and they stand outside your home. The cooks will already cook whatever is your delicacy. Everything will be already prepared and kept. You have to just go and eat, sleep, go and do your work. Okay, all your basic necessities, all your luxuries. In fact, I even had a jacuzzi also in my home. Okay, so all luxuries, everything is provided for you. Okay, so it is definitely a rosy life which you will have. But for me, it became a problem after some time. In the sense, I started feeling alienated with this common world, with the society. Okay, in fact, I would like to just travel in a train or a bus without being noticed. And in the job of an officer, as a sub-collector, you are always a celebrity. As an IAS officer, you are always a celebrity. Wherever you go, people would want to come. They want to take photos, selfies with you. So that kind of a life, somehow I was not actually feeling very convenient for my personality and my type. Okay, so these are some of the real reasons. All imaginary reasons you can think about political interference, about work pressure. No, that's a totally different kind of a job. You have to be inside that to understand what a job of an IAS officer is. Okay, so that's all. And moreover, there was also another family commitment. So my wife was also working in the service. Okay, she is working in Tamil Nadu. She is an IRS officer. So then I decided whether I should take her to Odisha or should I come back. At least me coming back here, I have a chance of once again coming back to Tamil Nadu, right? So I did not want to make her get transferred to Odisha and then live there. Okay, so these personal reasons, yes. So a lot of factors had a role in deciding why I had to quit IAS. Okay, but all these reasons are different from the reasons that you have given. Planning to jump into politics because of stressful routine. Okay, yes, that comfort zone is something that is a correct answer. So because of hardship in meeting your family in Coimbatore. Okay, that is not the correct answer, because Odisha as a state is well connected to airports. You see the state, geography of the state, you have the state here. If you are posted in these northern districts, Calcutta is available. If you are posted in southern districts, Vizag is available. If you are posted in coast, Bhubaneswar is there. If you are posted in the western part of Odisha, Raipur is here. And from all these places, I have a direct flight to Coimbatore. Okay, and you will be surprised. I used to start by 4 o'clock in the evening. So once I was posted as a sub-collector in a southern district, in one of the district here, 6 hours of travel I can reach Visakhapatnam. From there, it is just a 2.5 hours direct flight to Coimbatore. So within 8 hours, I'll be home. After that, I got posted in a place in the western part of Odisha. So I used to start within 3 hours. I'll reach Raipur, and from Raipur it is another 4 hours. So 7 hours was the maximum time for my journey. It takes more time for me to travel from Chennai to Coimbatore than from coming from Raipur to Coimbatore. Okay, so the distance factor is not at all a reason. Okay, as I told you, the reasons are there is so many factors which went into why I had to quit. Okay, so you can blame all these factors, can be given certain weightage. Okay, 20% weightage to that, 20% weightage to that, something like that. And to the person who had said jumping into politics, that is definitely not my cup of tea. So what do I say? You will have to live for somebody else. Job Politician's life is such a tough life, such a miserable life, my opinion, at least for me, the way I look at them, because I feel a life should be lived for oneself. Okay, you should live your life. As a bureaucrat, you have that privilege. You can live your life. You need not act you because you are not bothered to satisfy people. But a politician cannot afford to not satisfy people. Whenever someone gives him an invitation, he has to go and be present on that day. Otherwise, he will lose some 40-50 votes. Okay, it is by slowly pleasing all categories of people a politician can make some greater inroads, right? So a politician, you have to start living for the sake of others. You will not have your own time for your own passions, hobbies, or your own interests. Suddenly you would feel like going to a tourist spot, or you would want to spend some 2 days without cut off from this world. All that is not possible as a politician. You will always have to cater to what others think. Okay, what others think of you. Otherwise, then you would be a very bad politician. If you're not able to feel the pulse of the people, and if you're not able to feel if the people are approving you or not approving you, you would not be a good successful politician. Okay, so you will also always be occupied with thoughts on others' perception of yours. So that perception building is what the politicians would mostly spend their life. Okay, that is why they have all these big cars and outward display of very good clothing. Okay, always their clothes are clean, speckless, well pressed. That is how they would like to present, right? They would always want to present themselves as a role model, as a successful. So I think that comes more of the personalities and innate needs. They have this craving which I don't actually have. So it depends on person to person only. Okay, so I cannot, just that I don't feel myself good with a that kind of a politics. And politics is also not so interesting. Also, it's very boring. It's very very routine, and there's nothing interesting or challenging. Nothing. You have to. It is just a matter of competing with other competitors for a particular post. That's all. And you can never trust the people to vote on the basis of your merit or on the basis of your capacity. The society is not yet that matured, or society will take into many considerations before they vote. Okay, whether you're tall or short, whether you're fair or dark. Okay, but that is not the reason why I'm not entering into politics. I'm just saying a common man's mind is actually a very complicated one. It's not as simple as, because people really do not know what is required of a politician. So you guys tell me now that elections are just round the corner, and many of you are going to vote in the elections. Do you know? What do you think should be the requirement of a politician? So you would be choosing your candidates very soon. So tell me what would be the requirement of a candidate? If you guys know it, maybe you guys who are preparing for civil service examination are like the cream of the society. You are like the top 10% of the society. The remaining 90% of the society is completely different. You guys are at a different wavelength compared to the 90% of the society. Okay, so anybody, what do you think should not be a dynastic politician? Okay, he should have compassion for people. Okay, and what else? Anyone can get things done. So someone who can get things done, someone who has empathy, who has some values and ethics. No corruption, no corruption. Good face, please, because now it's lagging a lot. Lot of them look so dangerous. What I don't understand it. Good face, okay. Commitment. Well, in my opinion, your education, okay. Education is not necessary to be a politician. You should be a you don't have to be necessarily highly educated. Education is a criteria for so many things, but I don't think it's a meaningful criteria for politics. So because politics, you have to just know how to speak, because you have to represent the needs of your constituency. You have to be a member of that constituency. You have to have lived the life of a poor person of that constituency. Only then you can feel connect and empathy with that such kind of people. Only then you will be able to reflect their aspirations. You should be a man from the people. You should not be like Kamal Hassan going and standing in Coimbatore. Okay, he has no connection there. If you look at the video, it looks so funny. He's just going there as if he's a IAS officer going and inspecting things, just walking a casual stroll. So that is not the kind of politician I would choose, even though he might be talented. I'm a great fan of hers, but still I would not choose him as my representative. Why would I choose him? I want someone from that place, from someone who understands the pain of the people, someone who lives and deals and spends time with the people. Okay, he may not be educated. He need not be educated. He should just be in a position to go and speak well, to articulate, to question others well, and to have a clear thought. Okay, to communicate what is necessary for the people, and he should also have a vision of development. He should have a vision for taking the country, the people together, to greater heights. Okay, he should make people's life easier. I think I have summed it all. If you have all these, you will be a good you can be a good in my opinion. If you have these are the characters that are required for a good politician. Everything else is a waste of time. Okay, so uh, at least you guys have this much of idea, but you go and talk to a common man, most of them will give this opinion. Until now, it's only been two parties, so I want someone fresh, I want someone new. It is not a new person who can change this world. It is someone with a new vision who can change this world. People don't realize this. Okay, it's someone with a new way of life, someone who has lived his life in a different way, someone uh, someone who has his own conception of what development means. Okay, it is such a kind of a person people should be choosing and voting. If at all you think an alternative is better. Otherwise, in my opinion, I strongly believe the two Dravidian parties which have ruled Tamil Nadu are far, far better than any other political parties in whole country. Okay, best political parties that we have in this entire nation are the two Dravidian parties. So you should not. So people, when I interact, even the people who work here at the academy, when I just talk to them about who are you going to vote, so they say that I would vote for Kamala Hassan, I would vote for this person, that person. Why? Ask them why. Their only explanation is to give someone a new chance. Okay, so I think, see, if this is the kind of people that we have, either they would want to give someone a new chance, someone new a chance, or they would want to be die-hard loyalist of the same parties until their death, or they would want to just go and press nota. Okay, pressing nota is even bad, because someone who presses nota is actually wasting the chance of a better candidate, because you are the fool. If you press nota, you are the fool. If you have not done your due diligence, if you have not analyzed the character of each and every contestant, if you have not gone into their background, whether what they have achieved in their lives, whether is he going to be a honest person or not. Okay, if you have not done your due research and if you still go and press nota, you are the most uneducated among the group, among even an uneducated voter. Okay, someone who does not know how to read and write, if he or she goes and presses the button for DMK or ADMK, I think he or she is more informed and better at decision making than someone who goes and presses the nota. Okay, so don't waste your votes on nota. There are always better people among the contestants. So why waste on nota? Go and vote for them. If you don't know about other people, it's better to stick to Stick to people who at least have an experience of doing things. So yes, this is all about politics, and politics is all about representing people's interests, going and talking about people's problems all the time. So very repetitive, and I don't think I'm cut out. Okay, so that's all. That is all the answer. Hmm? Okay, we'll continue with our discussion. So we have discussed about the power of punishing for contempt of the court, right? Okay, this is done. Okay, this is done. Next is another power of the Supreme Court, which is given under Article 143 of the Constitution. This is what I had discussed yesterday as the power of President to make a reference to Supreme Court. Oh yeah, special leave is yet to be discussed. So what is this power? As I told you yesterday, the President is a layman. The President does not understand the intricacies of law, whether a law is good or bad. Someone has to advise him. That is why this power has been given in the Constitution. President can ask the Supreme Court for advice. Okay. So if the President makes a reference to the Supreme Court, is the Supreme Court bound to give an advice? What does the Constitution say? Is the Supreme Court bound to give an advice in case if the President makes a reference? What would be your answer? Yes, no, yes, yes. Okay. The correct answer is both yes and no. Okay. In some places, in some instances, the President is bound to give, Supreme Court is bound to give its opinion. Yes. In what matters? Constitution says on pre-constitutional matters, pre-constitutional treaties, the Supreme Court must give its advice. Okay. That is, let's say, instrument of accession between Jammu Kashmir and the state of Jammu Kashmir and the government of India. It is a pre-constitutional treaty. Before the constitution even came into existence, Jammu Kashmir had signed this instrument of accession with India. That was how Jammu Kashmir was able to become a part of India, right? So that's an example of pre-constitutional treaty. And the treaty between the state of Mysore and the Madras presidency for sharing of Kaveri river water. It is a pre-constitutional treaty. So such kind of matters, if the president has a doubt on any of these matters, he makes a reference to the Supreme Court. Supreme Court is bound to give its opinion. Supreme Court cannot refuse to give its opinion. But in certain matters, Supreme Court can refuse to give its opinion. What are those matters? If it is not a question of law, so what do I mean by not a question of law? Let us say when this Babri Masjid demolition case was being heard in the Supreme Court, 92 or 93 at that time, President had made a reference to Supreme Court. The question, so that there was a case going on, some Ismail Faruqi versus Union of India, such kind of a case was going on. So President made a reference to Supreme Court, and the question that he asked was, is there a Hindu temple or Hindu structure underlying the mosque? So this was a question that he had asked to the Supreme Court. And Supreme Court said, this is not an answer for us to answer. Let the archaeological department answer. We will only give questions about interpretation of the Constitution. If you have a doubt on question of law, please ask us. Okay. Not all kinds of questions is the Supreme Court bound to answer to the President. So Supreme Court, of course, can refuse answering a presidential reference, except a reference made on a pre-constitutional matter. Here, the Supreme Court is just bound to give its answer, right? So this is with reference to President's power of making a reference to the Supreme Court. Okay, even these presidential references, they are also discussed in open court. Did I discuss about a presidential reference yesterday? Yes or no? In what context did I make that example of a presidential reference? I gave an example. Okay, what was the example? The example was with respect to third judge's case. That was the example that I gave you with respect to how to proceed with the collegium system. So the Supreme Court gives its opinion, right? And Supreme Court, it's not like 5 judges sitting alone and giving their opinion. No, even a presidential reference made has to be answered through an open court. That is, lawyers should be appointed by the court. Supreme Court will appoint its own lawyers, arguing in favor of an opinion, against an opinion. So after hearing their arguments, then the Supreme Court will give a judgment. It will give its reply to the president. Okay, so the opinion given by the Supreme Court, even on a presidential reference, it becomes binding on all other lower courts in the country. If a president makes a reference and Supreme Court says this is how this constitutional provision has to be interpreted, okay, if a Supreme Court gives such a kind of reference, then it becomes binding on all other lower courts in the country. So this is about Article 143, power of president to make a reference to the Supreme Court. I'll have to discuss another article, constitutional provision, which is called as power of Supreme Court to grant special leave to appeal. It's a very, very powerful tool, powerful provision given in the Constitution, which makes Supreme Court the most powerful institution in this country among the courts. So let's see in what manner it is being achieved through the constitutional provision. What did I tell you about appeal? What is the principle involved in appeal? If someone challenges the decision of a high court in Supreme Court, are you challenging the decision for the foul play? If a person goes on an appeal, is it a challenge on the foul, on the intention of the judges, or the judges have done something wrong? That is why you are going and appealing it in Supreme Court. That is not the case. Okay, if you read the Constitution, the exact words that are being used is okay. Notwithstanding anything in the chapter, Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence passed or made by any court or tribunal in the territory of India. So let it be any body, whichever body passes any kind of an order, there is always an appeal. There is always one avenue to go and seek relief in Supreme Court. Okay, I'll just explain it to you. So let's say, yes, when it comes to appeal, you are just not satisfied with the judgment. You feel that there can be a better application of mind, there is a better interpretation possible, so that is why you're going to Supreme Court. But in special leave to appeal, the entire question is about lower court has done something blatantly against the principle of justice. Lower courts have involved in deliberate corruption, and that is why some gross injustice, some violation has happened. So Supreme Court has been given this power so that it can be the last resort. Supreme Court can rectify any such problem, any such mistakes done by the lower courts under it, so that the people's trust in judiciary remains alive. That is the reason. I'll give you an example. Let's say the chief minister's son, he goes to a bar. There is a woman who's dancing in the bar. So he asks her to do something and the girl refuses. So finally he gets angry, he takes up a gun and he shoots at her and she is killed. Okay, these kind of instances have actually happened in India. So the whole world knows that it is this guy who had actually murdered her. Okay, everybody had seen this event also. And who is going to prosecute? Let's say his name is Ram. So who is going to prosecute Ram in a court of law? Who is going to prosecute? It's the state of yes, Jessica case, it's going to be the state of Tamil Nadu. State of Tamil Nadu is going to prosecute against Ram. So who is going to be the investigating agencies? Investigating agencies, who will do that? It will be the same police which is under the control of Chief Minister. So they will do some botched up investigation. They will do some flaw investigation. They'll make the case very, very light. The case will not be properly investigated. And after that, a very mild FIR, okay, with a lot of loopholes will be filed. This FIR will be filed in a sessions court. At the sessions court level, the judges are so subservient. It's not like Supreme Court, they are not independent judges. They are very, very subservient to the ruling government. Okay. They are so subservient because there's a lot of ways they can be influenced. So it's very clear that the sessions court, after hearing this case, sessions court says evidence is not sufficient. So I'm going to let the accused go free. He is not accused. He is acquitted for want of evidence. Okay, but there is a huge public outcry, lot of demonstrations, lot of protests, everything is happening in the country. And now, if he has been acquitted, tell me who should now go on an appeal? Who should be going on an appeal here? If he is acquitted, who should go and file an appeal? The appeal is in High Court. Tell me who should file an appeal here? Okay, victim. No, yesterday only I had discussed with you. Yes, it's not her family, it's a state, it's the government which has to file an appeal. Because who are the parties? It's the Ram and Tamil Nadu state government is the party. So state government should go and file an appeal in High Court. But do you think the state of Tamil Nadu will go and challenge the order in High Court? It will not do. This is how miscarriage of justice will happen. So if this is the case, do you think citizens of this country should become hopeless? Law is dead in this country. We should start taking law in our own hands. We should all start using violence to protect ourselves. That should not happen. That is why, even if there is no appeal, the Supreme Court will take up this case itself. The Supreme Court itself can take up the case itself, or on the basis of anybody filing a petition, a special leave petition can be filed in Supreme Court. Okay. So normally the channel to reach Supreme Court is by process of appeal. You go on an appeal to High Court, and after High Court appeal also fails, only then you go on appeal to Supreme Court. That is the way how you go and reach Supreme Court. Otherwise it's not possible to reach Supreme Court. That is why it's called as special leave to appeal. You don't actually have to follow this appeal route to go up to Supreme Court. Anybody can go and file a special leave petition, special leave to appeal petition. That is, without even an appeal, I would want to reach out to Supreme Court to provide justice to this case. So Supreme Court will look into the petition. It will find that, oh yes, this seems to be a gross miscarriage of justice. People's trust is completely shattered. So what will the Supreme Court do? Supreme Court will immediately quash the order of this lower court. Supreme Court will quash the order of the lower court. Supreme Court will take up the case itself. It will hear the case and it will give a judgment. Okay. So this is the way how constitution makers have provided this extraordinary power in Supreme Court, that wherever it finds in any court of law there is a miscarriage of justice, Supreme Court can just take up the matter to itself. It can dispense away. It can give justice. Okay. So here you don't actually follow the appeal route. That is why it's called a special leave to appeal. You give a leave to the appeal. You put the appeal route aside. So, so this is something which is applicable to all courts in India, all tribunals, and that is why river water tribunals, Kaveri Water Tribunal, it has given a verdict, it has given an award, and the state of Tamil Nadu can still go and challenge it in Supreme Court by filing a special leave petition, because Interstates River Water Disputes Act, that is the act which has been passed so as to create tribunals for sorting out interstate river water disputes. Okay. So there is a constitutional provision. Article 262 talks about how to deal with river water disputes. If you read that provision, it will be mentioned that Parliament will create a body by law, and that body will be the final body. There is no further appeal. that will be the final deciding authority. Okay, so that is why after the constitution says that the body will be the final body, there will not be any appeal further. But still, then you may be wondering, how did the state of Tamil Nadu end up being in Supreme Court and challenging the order of the River Water Tribunal? Because special leave petition saying it's a miscarriage of justice to state of Tamil Nadu. The quantum of water allocation is very, very less. It's a miscarriage of justice, so please help us. And Supreme Court will exercise the discretion, and Supreme Court will entertain. So it has given a leave to appeal. Yes, there is no appeal available, and Supreme Court does not care about it because it has used this power. Any time, any court, any lower court, any order, any decree, any judgment can be taken up by the Supreme Court. It can be just be quashed. A fresh hearing can be done, and the court can give its decision. Okay. So this is what is called as the power of special leave to appeal, right? So this power is not available in the case of armed forces tribunal, except for armed forces tribunal, military tribunals, because those are totally different nature of crimes. So for those crimes, you cannot follow principles of justice. In military tribunals, it's more about bringing in discipline. It is more about seeking revenge. Okay, so it is for those reasons. In fact, if your own soldiers, they are ordered to march, go and fight Pakistan forces, and our soldiers, instead of going forward, they are returning back. They say, no, I'm scared of my life. I have my children and my kids are back home. Please, I don't want to go into the battle line and die. If that is the case, a commissioned officer, as per the Army Act, he can even order firing. He will constitute a tribunal immediately, and the tribunal will give a verdict. Fire on these soldiers. These are traitors. These are deserters. So fire on them. So the purpose is to bring in discipline in the army. If you die, you have to go march ahead and you have to die, not return back and die. Okay. So these kind of punishments might seem, those are the nature of punishments where you can keep on arguing whether it is really necessary to fire at our own men or not. But it is not to find justice in those areas. The purpose of armed forces tribunals is not to render justice. The purpose is to ensure our hierarchy and to ensure discipline. So those kind of aspects cannot be challenged in Supreme Court or anything. Okay. Maybe you can seek a mercy. You can ask the executive, because the army is under the control of executive. You can still ask the president for mercy. You can ask him, please pardon me. I have done something wrong. I should not be fired at. That can be done. But that's not a court process to find justice and injustice. So that is why Armed Forces Tribunal, they do not have a relief through appeal in Supreme Court or in high courts. Okay. So this is all about power of special leave to appeal. All other lower courts and tribunals, they come under the jurisdiction of SLP powers of Supreme Court. Armed Forces Tribunals, they are not under this particular provision of Supreme Court. So I'll ask you a question. So does it mean that there is no relief for army men? Can an army person punished by an armed forces tribunal, is there any way for him to access Supreme Court? You cannot appeal. You cannot file a special leave petition. If that is the case, is there any way of how such persons punished by armed forces tribunals, can they reach a Supreme Court in any manner? Very good answer. It's a writ jurisdiction. Every person, even if he is an enemy or whoever it is, there should be a process. The process is what is called as principle of natural justice. Okay. He should be allowed to speak out. At least he should be allowed to say that I was scared and that is why I ran behind. Without even giving him an opportunity to explain his position, if he is punished, that means that his principle of natural justice is violated. In that case, he can go and file a writ petition in the Supreme Court. So yes, writ jurisdiction would also cover armed forces tribunal, but it is not against the judgment given. It is about the process that is followed. Whether the judges in the armed forces tribunals, military judges, did they follow the proper procedure before giving their decision or not? It's not about the justness of the punishment that will be looked at. It will be about whether the proper processes are followed or not. If not, it would mean a violation of the basic rights of the person. Okay, right to be heard before being punished, that fundamental right is getting violated. So that is why you can move the Supreme Court using its writ jurisdiction. You can, but it's a very limited review. It's not about the entire sentence as such, but whether the process was properly followed or not. That is what will be examined when the writ petition is heard. Okay. So this is another jurisdiction. I think we are almost done. There are some other concepts that are to be taught. So tomorrow I'll have a discussion. I'll have a discussion of judicial review, judicial activism, and evolution of basic structure. Okay, so that is what we will be covering in the class tomorrow. So if you have doubts, you please go through your Lakshmikant, come tomorrow and ask questions. Oh yeah, there is another provision which I have forgotten to discuss. It is the power of Supreme Court to do complete justice under Article 142. Okay, I'll give you an assignment. Just find out how Article 142 has been recently used in the recent days, and come with an understanding of why Article 142 was even kept. The class is over. I have already messaged you. So we'll conclude it here and we'll continue with the rest of the discussion in the tomorrow's class. All right. Thank you.